The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning. We welcome everyone to our May session here in the state capitol in Harrisburg. I think everyone's familiar with the protocol for argument. It's in our operating procedures, and I think you also know by now that I take a few minutes and state the case, and then we begin argument. You want to call the first case, please?
Erie Insurance versus Michael Bristol, Mr. Daniel Siegel, Ms. Jessica Bowman.
Good morning. This case concerns an insurance claim that was subject to a mandatory arbitration provision. Court's asked to decide whether the statute of limitations was told when certain extrajudicial actions were taken in order to commence the arbitration proceeding to resolve a dispute regarding the claim.
Good morning. May it please the court, Daniel Siegel on behalf of Michael Bristol. The issue here in this contract action is whether the role of the courts is to resolve disputes or warehouse them. In this particular case, the contract was an uninsured motorist provision in a motor vehicle insurance contract, which relied upon and was based upon the Uniform Arbitration Act of 1927. That provision requires parties to seek judicial intervention only when a party refuses to arbitrate. Both the trial court and the superior court disregarded that language and instead essentially used tort law or negligence principles to create a statute of limitations that is based upon the date of the accident. That is inconsistent with the principles that this court has established for decades, that a cause of action only accrues when there is a right to institute a suit.
You see, this is the problem. It runs throughout your brief. You've tried to change the question upon which we granted aliquotter. We didn't grant aliquotter to revisit Hopkins. We granted aliquotter on whether it's told when you have this claim that you demanded arbitration, which, by the way, I don't think you did. And you want to take us in an entirely different direction. I think what you need to do is convince us why a letter putting the carrier on notice tolls the statute of limitations, which runs under settled law from the time of the hit and run. That law is not before us today.
Justice Wecht, the issue that, as the court reframed the issue was whether extrajudicial actions would serve to toll the statute of limitations.
Right, so why don't you tell us what extrajudicial actions Bristol took that could toll the statute of limitations?
The extrajudicial actions here were actually twofold. Bristol first demanded arbitration. The carrier, extrajudicial action, appointed an arbitrator. Extrajudicial action, the carrier took a statement under oath of Michael Bristol, an extensive 3 to 4 hour statement in 2008, well before any statute of limitations had run. Thus, there were multiple extrajudicial actions taken on behalf of both parties consistent with the contract language.
What prevented him from filing at any time a petition to compel arbitration in accordance with the rules? We have a rule of civil procedure, Rule 1329, specifically providing for that. Didn't he just miss that?
No, because this is a contract action, and while the rule provides for filing an action, the purpose would have been to compel Erie to take an action. There was nothing to compel Erie to do. Erie had already agreed, consistent with the language of its policy, to proceed to arbitration. And that is sort of the concept that underlies this case. Filing a petition to compel arbitration in this case, where Erie's extrajudicial actions and Mr. Bristol's extrajudicial actions were commencing arbitration, would have simply asked the court to compel something that both parties had already agreed to do. There was never a breach.
Pardon me, it seems to me that the plaintiff was simply following the policy in every step. Is that, I mean, am I reading that right?
That's correct, Justice. And that underlies the argument that exists in these cases.
But all that he did was write a letter putting them on notice. It was Erie that initiated arbitration, and that was what, more than a year after the statute had run.
No, I would disagree in terms of the timeline. Erie took a statement under oath that was a 3 to 4 hour statement consistent with the uninsured motorist claim that showed that it was entering into arbitration. It appointed an arbitrator. Both parties took extrajudicial action, and I don't think that you can look at the facts here solely on the basis of what Michael Bristol did, because this is a contract.
Because he basically didn't do anything. I mean, is there ever a case that we've decided where we have engaged in such incredibly robust equitable tolling?
Well, I don't believe it's robust equitable tolling. I believe what we have here is a contract, and there is language in that contract that the court has to interpret under contract principles, and then the contract refers to the Uniform Arbitration Act of 1927. And this court has, in cases interpreting both the Uniform Arbitration Act of 1927 and its successor, affirmed the principle that that in order to invoke a court's jurisdiction, there must be either a refusal or a denial to arbitrate. And what the Superior Court did in this case was disregard the language of the contract completely. The Superior Court did not look at the Uniform Arbitration Act of 1927 and instead imposed a strict statute of limitation requirement of 4 years from the date of the accident.
Isn't the statute that you're trying to latch onto the statute? It's section 7304 that addresses cases where there's an issue the court has to resolve regarding the enforceability or scope of the arbitration agreement, which is not what we have here?
No, 7304 refers also to section 7303 that says the parties would seek judicial relief only when a party refuses to arbitrate. That's the language in the statute. There is no evidence in this record, and in fact, if you look at the declaratory judgment action filed by Erie, Erie never alleges that it refused to arbitrate. Erie never alleges that Mr. Bristol refused to arbitrate. It merely sought to essentially ignore the section 73 and 7304 language and compel arbitration. As a result, and when looking at Erie's brief, this court can look at this case in terms of the non-extrajudicial actions, but it's extrajudicial actions in terms of the context of a contract. Because while this is motor vehicle insurance law, all motor vehicle policies, whether pre-Kochen or post-Kochen, determine the rights of the parties. And the carrier specified the rights of the parties here. And the carrier said in the policy, typical of a policy written before Kochen, that you must arbitrate based on the Uniform Arbitration Act. But then they sought the relief completely separate from the Uniform Arbitration Act, and that's never cited by them in their request for relief. In fact, their brief offers this court two alternatives. One alternative is the alternative that Hopkins in the case below, that is 4 years from the date of the accident.
That's not, again, there you go. That's not what we granted. That you could have sought aliquotter. You could have sat, and maybe you would have got aliquotter on us looking to reverse Hopkins. I mean, that's just not. We just don't have that. We can't reach for that, even though you've tried in your brief. So the question really is, before July 22, 2009, list for us what your client did to toll this statute. Was there anything other than a letter putting Erie on notice, whatever that means?
Yes.
Anything?
Yes.
Before that date?
Yes, there was the statement under oath that he gave a deposition, in essence, that was 3 to 4 hours, extensively questioning him as to the circumstances of the accident, as to his injuries, as to all of the circumstances that occurred with regard to this. So there was, Erie, upon notice of the claim from Mr. Bristol, their extrajudicial action and
So
his.
I think I pinned you down. So you want to rule from this court that any time a driver, a motorist, enters into some negotiations with a carrier, even though the driver misses the statute, files nothing with the court, that we're going to look back and toll the statute that they missed simply because they were in touch with the carrier. It sounds like you want a rule excusing well, I don't know, legal negligence, motorist negligence, call it what you will.
No, that's not what we're suggesting. In this particular case, there was the statement under oath, which is an affirmative action by the carrier in appointing counsel and in taking the statement. This is very different from a circumstance where counsel or the claimant simply sends a letter to a carrier and nothing happens. In those circumstances, the claimant would be obligated because there was never an agreement, there was never any affirmative conduct by the insured under the policy to invoke the arbitration provisions.
I'm going to shut up after this. Let me just try to nail this down. So I leave here today. I have a collision with another motorist. State Farm or Allstate or whoever is the carrier for the other motorist. They take a statement from me. And then I just missed this, the years go by, I missed the statute. You're saying that because I gave a statement that I should have the benefit of tolling of the statute that I missed.
Not specifically, let me clarify. There's a difference between giving a statement that is routinely requested after a motor vehicle accident, that if you were in an accident today, your carrier would request. This was a statement, and it's demonstrated in the record, that was taken as part of the claim, the formal claim that was made for uninsured motorist benefits. If you're in an accident today, Justice Weck, and your carrier simply takes a statement, what happened, and you explain, a la Michael Bristol, that I was in an accident and the vehicle fled the scene, that would not invoke...
His carrier.
Yeah.
Or the UM carrier.
The UM carrier was his carrier.
Okay.
So that would not invoke the UM provisions of the policy, because at that point, while he may have known that there was a UM claim, he doesn't really know that until you proceed further. In this case, there are the further steps, and the extrajudicial action was Erie agreeing, hiring counsel, and taking a statement in the context of an uninsured motorist claim, as opposed to simply taking the routine statements that any carrier does following an accident. I believe there's a difference in those two approaches. And as a result, that is the extrajudicial action that created the situation in which the claimant had no reason to believe that Erie was disputing its obligation to pay benefits, disputing its obligations under its contract with Michael Bristol to provide those benefits. And in fact, the history here, as shown in the record, was that counsel for both parties agreed that while there was a period while Mr. Bristol was actually incarcerated, that they would defer the proceedings until his release. Those were all extrajudicial actions, and they were all...
Interrupt you. Have you answered Justice Weck's question?
I believe so.
Okay. Here's what I think he's getting at, and I'm trying to listen to this hard. You have a statute of limitations. You have a date it begins to run. And then 4 years later, you have a date that it tolls, because it's a statute of limitations in contract. Is that fair?
Well, the question, and as Justice Weck said, that the court, if you look at this under contract principles, is what is the date on which that statute of limitations begins to run?
Where's the breach? Isn't the statute triggered by a breach by Erie, and where's the breach?
Well, that Justice Todd, is our point. There
We
was
didn't
never.
grant that.
But-
We did
but,
not grant a
yeah.
revisiting of Hopkins. You could have sought that.
I think
If
it's
I-
sort of
if I might-
implicit in what his argument is, but I interrupt.
Well, yeah, and if I might,
Yes.
because again, I think you're almost done, so I want to make sure we straighten this out. I think that there may well be an issue, important issue lurking here. The Superior Court cited American States versus Laflamme, the Rhode Island case. And the important issue here is, as Justice Todd just said to you, when does the statute of limitation begin to run? Not when is it told, but when does it begin to run? The difficulty, as I think Justice Wecht has said to you, is that may not be encompassed within our grant. Therefore, we're going to have to, at some point, get to the fact of if this is a contract action, does the statute of limitation begin to run from breach rather than from date of accident or some amorphous date? And it appears that Pennsylvania is an outlier in the United States because we've gotten this wrong. But the difficulty is, and again, I think this is what's being said here, and I'm trying to get it straightened out. Did we grant on that issue, or are we stuck with our grant, which is this is about when it tolls and not when it begins to run? And if you can answer that, I think we can move on.
Yes. I believe that subsumed within the question of whether an extrajudicial action tolls the statute is what are those actions and do they demonstrate a breach? I don't see how you can analyze the claim, a contract claim, without looking at the contract, without looking at the circumstances of breach. And in anticipation of the argument today, we verified currently 15 states take the Laflamme approach, 15 Supreme Court, saying that there must be a breach before there is a claim before the statute of limitations runs. Two state Supreme Courts say to the contrary. As a result, the extrajudicial action would be agreeing to proceed, or alternatively, if Erie in this case, or a carrier in any other case, simply wrote a letter or advised claimant's counsel, we are either denying your claim, we're not going to arbitrate. That extrajudicial action, which at that point triggers the breach of contract, is what underlies these claims, and it's an issue that simply has escaped review in Pennsylvania until Hopkins and until this.
Well, it's going to escape review again because I'm looking at a question we granted on, and it does not talk about when the clock starts running. The Superior Court's case law might be completely wrong. Maybe you'd win 7-0 on that. But it's not, we granted the following. In uninsured motorist claims subject to mandatory arbitration, is the statute of limitations told only by the commencement of an official judicial action, or may extrajudicial actions also toll the statute of limitations? I guess you could have asked for reconsideration to ask us to consider Hopkins.
Well, I think under that specific question, this court can simply say, yes, the statute of limitations is told based on extrajudicial actions, and in this case, the extrajudicial actions were the taking of the statement under oath, proceeding with the arbitration, agreeing to defer arbitration while Mr. Bristol was incarcerated. And then the court doesn't have to reach the breach of contract issue, but it would still be addressing the underlying conduct of the parties, which is explicit in the question that was granted. Either way you analyze this, whether you go and consider contract principles or simply look at that question, it is not just Michael Bristol's extrajudicial actions, and the question isn't framed that way. It was the extrajudicial actions, and that's two parties to a contract. And in this case, the party to the contract, Erie, which took the statement, which retained counsel, which did all of those extrajudicial actions, never invoking the jurisdiction of a court, was the same party that now comes into court and says, oh, by the way, you didn't file a petition to compel arbitration or a complaint within 4 years.
Can I stop you there, counsel?
Yes.
Because this is where I get very confused. And that's why I'm having a harder time than my colleague in separating these two issues. I don't know how you file a petition to arbitrate if there is not a refusal to arbitrate. And there is no refusal to arbitrate in this case. In fact, as you pointed out, there was a statement taken pursuant to the protocols under the the procedures to make a claim for uninsured motorist benefits. And although it may have been outside of the statute of limitations, there was an arbitrator appointed. So, I mean, I don't know what you could do. I mean, what do you do? File a petition to arbitrate that says there really has not been a refusal to arbitrate in this case, but I'm filing this anyway. So what have we created? A protective petition to arbitrate, the way people file protective precipes in common law causes of action. This is not a common law cause of action. This is driven by statute as to how you proceed to arbitration, i.e. you petition to arbitrate, and it's driven by the fact that you don't file a complaint. You file a petition to arbitrate. That's why this discussion of file a lawsuit, file a petition to arbitrate, there's only one way to proceed here. You have to file a petition to arbitrate. And I'm not aware of a piece of paper called protective precipice / petition to arbitrate. You need a refusal to arbitrate. You need a breach in order to trigger this process.
I agree, and as we say in our brief, if Mr. Bristol had filed a petition to compel arbitration, he would have been filing a petition to compel Erie to do what it had already agreed to do, and that's
plead what you need to. You could not allege what you need to allege to file a petition to arbitrate, i.e. there has been a refusal to arbitrate.
I completely agree, and
It seems to me that maybe an element of confusion was added by rephrasing the original question.
that is possible.
We'll deal with that, but unless anybody has any questions, I think we apprehend your argument.
Thank you.
Ms. Bowman.
Good morning, Justices. May it please the Court. I'm Jessica Bowman for Erie Insurance Exchange. And I'd just like to point out, to begin with, that on all levels in litigation, there are certain deadlines that have to be met to file a tort action. There's 2 years. This commencing the tort action. Whether or not you are this close to settlement with, a claims representative or this close to settlement with, another attorney, you have to file even a writ just to toll that action. I understand that, with this, there were negotiations, there were arbitrators set, but something has to be filed to toll the actions. That's how everything has been within these systems, within how we work. And it would completely go behind everything, and it would really disrupt the system, even in UIM actions, if nothing had to be filed in order to keep it moving.
Well, let me ask you this. What about this notion? You're talking about a statute of limitations. But how about the notion that doesn't begin to run until either the carrier denies the claim or refuses to proceed to arbitration?
Well, actually, Your Honor, in uninsured motorist actions, I don't believe this court has ever ruled on it, but under the Superior Court rules, the statute actually begins to run when there's been an accident, there's been an injury, and when the claimant knows that there is not insurance or proper insurance on the either uninsured or underinsured motorist. And in this case, Mr. Bristol was involved in a hit and run accident.
We understand that, but let me try it again.
Of course.
You need a triggering event. How about this? Either the carrier refuses to pay the claim or refuses to arbitrate. That event triggers the statute.
Triggers the statute or triggers the tolling of the statute, Your Honor?
No, the run date on the statute.
Right, I understand that in most contract cases, that's how it operates.
Did either of those events occur here?
I do not believe that either of those events did
Then why
occur.
is there a statute of limitations issue?
Because under the case law that stands today by the Superior Court, the statute had run under what I...
Does that make sense to you?
I believe so, Your Honor, because I believe that uninsured and underinsured motorists are not quite the normal contracts. If we did a statute by the time a uninsured motorist contract was breached and or arbitration was refused, an injured party could wait, honestly, decades to go to their uninsured motorist coverage and say, oh, 15, 20 years ago, I was hit, you need to pay me, and then they say, no, we're not paying you, then that breach occurs.
The carrier could solve that by moving to arbitration.
I'm sorry?
The carrier couldn't solve that problem by moving to arbitration.
They could, Your Honor, but, you know.
Doesn't the carrier, and I'm trying to be consistent with the Chief Justice, not to interrupt him. The carrier has lots of protections from that. You have in your, and we've heard these cases, in your policies, they only have so long to do to report it to you. And if not, they've waived it, and that's so that you can go investigate it and begin the process. So they can't come to you 10 years later. They can't even come to you 90 days later if we accept your positions.
Well, Your Honor, while that's true reporting, I think that is, you know, goes to what the extrajudicial action is then, and what tolls this, you know, that's all extrajudicial action.
Well, but the chief is saying to you, and it's really an interesting case. Within our grant, you never get the tolling if it didn't begin to run, and it's a contract, so it runs by breach. Justice Donahue said that to the other side. That's what the chief said to you.
If that was in our grant, but
Yeah.
It doesn't appear to be. Wouldn't you agree with me that that's not in our grant?
I do agree that it
And
is
we need
not-
a plaintiff to bring the Hopkins issue to us.
And I agree that, you know, maybe within the Hopkins issue, but as it's established at this point, and as we said, if this was, and I did respond to that within my brief, but if this is a case about when the statute begins to toll, it would be different. But as it stands, and as it stood when Mr. Bristol was bringing the claim, and under the rules, the statute began to toll when he knew that the car was uninsured. The other car was not insured.
Began to run, not be.
Began to run, I apologize.
I interrupted the chief, and I apologize for that. Let the chief finish his questions.
No, I think we understand it, but irrespective of how the question's phrased, and the issue, we have the case, and the issue is still at base. The issue, did the Superior Court err in its determination? And the appellant, as I read the papers, maintains that the statute doesn't run until either there's a denial of payment under the policy or a refusal to arbitrate. So maybe you could
Of course.
focus on that.
Of course, and you know, while I agree in most contract actions, that's when it begins to run. I think that within these uninsured and underinsured motorists, it's a little bit different than a normal contract action, as in you know that you're injured as of the date of the accident. Usually when there's a breach, say you sold a house and someone breaches the contract.
It's not a tort claim.
I understand.
It's an insurance contract, and there's a statute of limitations issue, and the Superior Court said that you've lost the statute, but we need a beginning date.
No, and I understand, and I agree with you, Your Honor. I believe that uninsured and underinsured motorists, since they sound in an original tort, that it's somewhat different than your base contract, because you do know that injuries occur at the date of the accident, is the only response I could.
Counsel, can I just ask you from a practitioner's standpoint? The problem I see with the fact scenario that we're dealing with here, the insured really cannot do what is required of him to do in order to quote, get arbitration. He would have to file a piece of paper that says there has been a refusal to arbitrate, because that's how you trigger arbitration. I mean, and I don't know if that's just the endemic incorrectness of the Hopkins statute of limitations, or if it's a variation presented in this case. But this claimant could not legitimately toll the statute of limitations by filing a piece of paper that says there has been a refusal to arbitrate. So how do you get around that?
Well, I agree. I believe, and I could be wrong, but I believe that a writ could be filed in this case, or, I believe that something could be filed saying arbitration is not being, moved along.
Where would one get that authority? I mean, there is a statutory mechanism to trigger arbitration. It is to file a petition to arbitrate. This isn't something that you could file a precipice, a protective precipice. That's just not what's at play in this particular, granted, unique situation where you have, arbitration to adjudicate a claim.
Well, for one thing, you could have filed a precipice for writ of summons, right?
For what? I mean, that's my point. And what would it would have been for? A writ of summons for breach of contract?
Yes, Your Honor. I believe so. And as I believe that, Justice Ott, in her concurring opinion, even says that she would draw a bright line rule saying that something like along those lines, a writ or a summons must be filed to toll the statute. I believe that the same thing was occurring in the Hopkins case. There had been discussions, and how do you say someone's refusing to arbitrate? Is it just a delay? Is it an outright refusal? I think that, drawing the line where somebody's refusing to arbitrate kind of muddies the water in that being the, the tolling.
But that's always the case in breach of contract actions. So, according to Judge Ott, who I respect greatly, and she wrote a great opinion, we're essentially creating a new judicial proceeding to backstop the arbitration act's procedure because we have a statute of limitations that's not based on a breach of contract. I mean, that's how convoluted, that's the logical extension of what we're doing here if we follow that thought process.
Right, but I believe that would be a good bright line to draw, and it would obviously would not have had us here today, and I think that it would clarify a lot of other issues within that realm as well.
Good answer, thank you.
Thank you.
Anything else?
No, thank you, Your Honor.
Thank you. Thanks to both of you.
Commonwealth of Pennsylvania versus Leon Miller.